the office because I went back to talk to her. I'm so sorry. I couldn't get it to scan. I think I tried to tell Heather, but if we can adjourn for a couple weeks, I'll get everything sent over.
All right, if we have nothing today, she's gonna stay in custody.
Well, we have the paperwork.
No, I don't have anything.
Can we have her come back next week?
Yeah, from the jail.
Yeah, please say something.
You didn't send over to the department.
I sent it over to my other agent. He has it all.
She said,
And I did send it to probation. Ma'am, I have a job. I just started last week. I'm done a very good path right now. Please don't put me in jail.
Ma'am, you're ordered to test.
Can I
And you are
explain?
not doing that. You haven't been doing it since you've been on bond,
Can
actually.
I explain, ma'am? Okay,
I'm sick of your explanation.
I'm sorry.
to be
I was
honest.
very sick. I have doctor's notes. There's doctor notes in there. I had surgery. They just took my other cast off and gave me a
she
removable
couldn't
cast
test because she had,
because this hand's paralyzed, so I
And-
couldn't drop with the other cast.
she just
So-
got a
I'm
removal.
sorry, what?
Okay, let me talk. She had a regular cast on. She just got a removable cast, so she couldn't test.
You can't test because you have a cast on your arm?
She said she had a regular
I
cast
can't
on.
cup, I'm sorry, ma'am, I can't cup the cup with this hand with the other cast on, and this hand's paralyzed. So they gave me a removable cast, and I talked to Mr. Levitt, and as soon as I removed it, I went immediately in and dropped. I've been good on my tether, I'm on a GPS tether, I'm not trying to run from nothing, I'm trying to clean up my life and get my life together. I got a real job, I'm not on Social Security no more. You know, I didn't, when I did the assessment, I couldn't control the time frame that she got that into you. And then when she did the assessment over the phone with me, she was off work last week until today. So that's why my appointment is at 2:00, ma'am. I'm not trying to violate nothing. I'm trying to get my life together and do good.
They have hats that they use when people can't use the cup.
Well, they didn't say nothing to me. I asked Mr. Levitt if he could mouse swap me, and he said that's not what the judge ordered. She ordered urine tests. I even asked, is it Lynn Schroeder? I even brought it to her attention to community care corrections. I called, I said, can they start mouse swapping me, or can he come to my residence or whatever, so I don't get violated? And they said, no, the judge ordered urine screens. I inquired about it, ma'am. I didn't want no violation. I'm doing so good in my life right now.
Ms. McDuffie, what would you like to say?
So first of all, just so that Ms. Law is aware, I don't think she understood what the court just said. They have hats when you can't use the cups. A hat is a fairly large plastic, wider container that fits over the seat of a toilet so that there's no cup necessary and the urine goes directly there. We're still talking about urine tests, but that's
I
a
didn't know
device.
that. Tell me.
Ms. Law, now is not a good time for you to say anything, plus I'm talking. That is something that they use when people aren't able to use the cups. I'm saying that just so that she understands what that is, what it means. Next. I don't know when Ms. Law was in touch with her tether agent. What I don't understand is how we managed to get a report from Agent Levitt, at least dated February 8th, that simply has missed tests, positive tests. Usually the reports that we get are pretty detailed with narrative if there's been communication with the defendant who's under a testing order when they say things like they have an issue, aren't able to test because of this reason. It doesn't say unable, missed, it just says missed. There's notes from fall of 2023 that have commentary about the things that Ms. Law explained to the agent and to community corrections regarding doctor's notes, not able to provide samples, car trouble, provided pictures of flat tire. But all of that evidence of communication is missing. All we have between basically then and now is just missed tests. It doesn't reflect any conversations with Agent Levitt. I'm not saying that she did or didn't, but I'm saying it looks awfully different from when we've had that evidence before. I don't know if she just contacted Agent Levitt today or in the last 2 days. I'm very confused about why there's proof of prescriptions coming in today. Again, I'm not speaking as to when Ms. Law contacted her attorney, but there's a whole lot of last minute shuffling of papers and things and explanations coming in when the consequence, she had a jail wreck, I think the last time. So Ms. Law knows that her history in this court with her extended failures to appear with the testing issues, Ms. Law knows that she doesn't really have any room to be making mistakes, and we all make mistakes and none of us are error-proof, but she knows that there's not any wiggle room here and that she's got to be in extremely good touch with everybody, with her attorney, with her agent, with the court, to do whatever she can to make sure we have all the information that we can get. I believe Ms. Law is having a difficult time. I know that she does have health issues, but I'm missing an explanation, and I can reach out to Agent Levitt right now. If I had known that we were going to come back from that breakout with no progress, I would have done it then. But I can reach out to Agent Levitt and ask him to pop in and tell us what he knows about this situation and if he's gotten any contact, at least since this report came out, for some clarity. But other than that, I'm at a loss as to why we're here in this situation right now.
Can I talk, ma'am?
No, I was gonna ask if I may.
Okay.
If I may respond?
You can explain why we're in this position right now?
No,
Say whatever you want to say.
just that since I do have the paperwork, I would like a week and for Ms. Law to stay out to get proof of the assessment.
I heard that part already.
Okay, nothing new.
Can I please talk?
I don't think we have anything new.
I do. I have an explanation for what she just said to me.
Ms. Law would like to make a comment.
Ms. Law, if you're repeating the same thing you said already.
I'm not.
Ma'am, don't talk over
I'm
me.
sorry.
If you're repeating the same thing you've said to me, it is only going to make your situation worse.
No, I want to respond to this lady on
If
TV.
it's something you've said already, it will only make your situation worse.
It's not, okay. When I called the doctor, Mr. Levitt, nobody never told me about the hand.
Okay, you
or
did
I
say
went to
that.
read this
You
other
said
thing.
that
I have
already.
proof in my phone right now. He wants to walk me out to the car, my conversations through email with Mr. Levitt, letting him know about me not being able to drop because of the cats and stuff. I did communicate, he did respond back. It's all through email in my phone.
Did the court want me to see if he can come run?
No, I don't. Thank you.
Mhm.
You can bring the phone in here. Of course you can't run it in.
This is what I'm going to do. I'm gonna adjourn this hearing until Thursday. I'm gonna give you a chance to get your documents in. It's not your fault that your attorney wasn't able to scan them and get them over to the prosecutor. If you don't show up here, or if you don't have proof, like you said you do, from Hagira, or proof that you actually have these prescriptions, I know there've been some in the past, I'm going to put you in custody, ma'am.
I understand that, ma'am, and I will have all of that. I want to have them.
I'm no longer playing with you, Ms.
I
Law.
understand that, ma'am, and I'm, when I go today and sign the paperwork, I want to ask her to fax it right in front of me or email it, whatever she has to do to probation. I'm not trying to hide nothing. And I will be here. I'm on a GPS tether.
2:15, 24:11 a.m. in person again. You need to be in touch with your attorney before then to find out whether you want a hearing on these things or not.
Okay, well, I didn't get a phone call from my attorney till the weekend, so I didn't know, and that's the only contact I've had since we've been in court on Zoom. Right, I called you, I told you I had all this stuff and I have a job and all that. And then you called me on the weekend. That's the only 2 times I've talked to you.
That's true.
We'll see you on February 15th at 11.
Thank you.
Thank you, ma'am. Thank you for understanding.
Short phone, you can bring it in as long as it's on silent.
Okay, I didn't know because they did that where you couldn't bring your phone, so I left it in the car, but I keep everything for proof. Can you get my paperwork, please?
Yes, come with me. Yeah.
Thank you, guys.
She's gonna get.
She has a notice for you, ma'am. Wait one moment.
You can go ahead and walk with her.
I'm sorry, what was that?
Come on here, come on.
Ma'am, go out there. I've got a piece of paper to give you, so stand by.
Okay.
Thank you.
Have the bond violation to handle?
Your Honor, if I'm not mistaken, Mr. Brewer's bond violation may be his pending felony. Let me just see if there's any.
Well, he might have several things going on, but one of them is from community corrections.
Oh, that's right, there is. Sorry about that.
Just confused about what happened in this file.
Well, Mr. Brewer, this got set for a final settlement conference, I think right around that same time, so we never really addressed it. And he is actually scheduled to be in custody, I think. Well, I don't know in custody necessarily, but his felony cases adjourned out to April. So realistically,
So when we were here for the final settlement conference on January the 25th, that's when we adjourned it to today's date to
yes.
figure out what was going on with the felony.
Yeah, it was set for jury selection, and then we did a step to adjourn the jury selection to discuss a potential resolution. So we never
see.
actually.
Okay, that's what happened. That's why there are no notes in my ROA, and I'm trying to figure out what happened. Okay, thank you.
And I'm sorry, Your Honor, I'm coming in late. I'm taking Mr. Brewer's case. So
I see the step here. They didn't write in the file that the step had come in. All right. Thank you. So what do you want to do today, Ms.
Your Honor, we do want to proceed with this. Mr. Brewer, I think, and I'm sorry if I just missed what was discussed. Mr. Brewer would, from my understanding, and I think what was just discussed, it was already indicated that the state could proceed on the matter. Mr. Brewer doesn't want to delay the matter, so he would, I don't know if that's possible to go directly to jury selection. Or do we need to set it again for final settlement conference?
It won't be the sense of setting for a final conference again. I've already done that.
Mr. Brewer,
Okay, Mr. Brewer.
you don't decide that, I do.
I understand that, but I've been sitting here in the county jail for nothing. I mean, can we just move forward? I don't want no more pausing. I prefer to go to
Mr. Brewer,
trial.
it's okay. We'll figure it out. Okay, that's the judge's decision. Okay, so just a
I
moment,
heard her.
please.
Yes, ma'am. I heard her.
Okay.
So, Your Honor, just to confirm for the record, I do need to make sure that Mr. Brewer understands the offer that I extended for Mr. Brewer, because that was the purpose of us adjourning, was to see how this could be resolved with his felony. His felony, unfortunately, is not in a position to have any reductions or consideration added to it. And they adjourned in that case before Judge Slay out to April 4th because she would not agree to a COBS for no prison. So they're trying to do some mitigation there in terms of what a potential sentence could be. Here, Mr. Brewer, when I discussed this case with the other APA, we looked at this file more closely and realized there was an active PPO in place at the time of this. And so this actually should be a felony aggravated stalking offense as well. But the offer was to just leave that alone essentially and not reauthorize that, which would restart this case with a brand new charge. So, and send it back, which would extend it longer too. So, to not reauthorize this as a felony aggravated stalking offense with the addition of that to the existing DV second. And Mr. Brewer's other aspect of that offer was to basically plead guilty as charged to the DV second, either guilty or no contest. The sentence agreement would be to simply close the case out with credit for his time served. So that is what he is rejecting, is to close this case out today with credit for time served with the plea to the misdemeanor.
That is what I communicated to Mr. Brewer yesterday evening. He indicated to me he did not want to accept that offer. Is that still correct, Mr. Brewer?
That is absolutely correct.
All right. So in light of that, Ms. McDuffie, what are you asking to do?
Well, given that if Mr. Brewer is rejecting that offer, that means that I need to reauthorize this case, and so it's going to restart. So we can actually set it for the final settlement conference. So that'll give me time to get the new charge authorized, and then that'll make its way through and he can get arraigned on that and, see what happens there. So I guess the final settlement conference does provide a date that will serve a purpose in this situation.
I see counsel in the breakout room, please.
Mhm.
All right, we're back on the record in the Terry Brewer matter. In talking to the prosecutor, it's my understanding that she chooses, and it's well within her discretion, to not dismiss at this time. And she wishes to set this for a final settlement conference. A final settlement conference would be scheduled on March 28th. However, I am at this point going to set this for another pretrial, at which time, if there is going to be a reauthorization of this case, the court is requesting that it be done no later than that March 11th date. There's no need for us to wait until the March 28th date if that is what the prosecutor intends to do. So I will set this for a pretrial on March 11th, 2024 at 9 a.m. Mr. Brewer, you understand what she's saying? You're muted, sir.
Yes, ma'am.
Not you. Your name is not Brewer, Mr. Kennedy. Can you please get them?
Can you hear me now?
I can. Do you understand what the prosecutor is saying, sir?
Yeah, the prosecutor's saying that she's going to add an addition. She's going to change the charge to aggravated stalking.
She's going to add that.
Because I'm not willing to take a cop to being in here and perhaps wanting to beat my charge. So you raised the charge?
Mr. Brewer, you do understand, though, that she's adding a charge. So it's not just.
Yes.
Okay.
I understand.
All right. All right. So March 11th for that pretrial, and then March 28th, 2024 is the final settlement conference. The next jury selection is not until April 5th, 2020.
Why do I have to do the conference again? I mean, I've gone through it. I'm not taking a cop on nothing.
Mr. Brewer.
She's enhanced the charges.
Because I said so, Mr. Brewer.
Okay, I get that you said so, but we can just move forward.
So, sir, do you want a contempt charge added to what you're saying?
If that's what you want to add, then yeah. If that's what you want to add, then add that.
Sir.
If that's what you want to add.
Mr. Brewer, let's talk after court, okay? I can explain, okay?
Yeah, man, come on, man. These intimidation tactics. I mean, what's the purpose?
This is not intimidation.
Yes, it is.
Sir. You know, contempt is stacked on top of whatever time you're doing.
Whatever it is you want to do, Your Honor, then go ahead and do it. All I'm doing is asking an honest question. I've been locked up since November.
And I gave you your answer.
Mr. Brewer, you'll be there on your felony matter anyways, okay? So we're getting this misdemeanor taken care of as soon as we can. Okay, please don't say anything further. Let's talk after court, please.
I will see you back here on March 11th, sir.
All right.
Did you?
If I may, Your Honor?
You may.
Okay. Ma'am, were you at that time on December 18, 2023 in a dating relationship with an individual by the name of Don Lee?
Yes.
And on that date and time and at that location, did you physically assault Mr. Lee by hitting him on his chest with your closed fists?
Because I didn't want him to leave me.
Okay, I'm sorry, I could not make that out.
Yes,
did you hit
yes.
him on your chest with your hands or fist?
I did this on his chest because he was
Ma'am?
gonna leave me. And
Ma'am?
I'm sorry.
Ma'am?
Yes. I'm sorry.
Thank you.
Yes, I did bang him on his chest.
I have nothing further, Your Honor.
Sorry.
Anything from the people?
Ms. Kreischer, I'm sure we can stipulate to the fact that Mr. Lee did not want that contact.
Yes, we would stipulate to that, yes. Thank you.
Given that, Your Honor, the people are satisfied.
All right. Are you satisfied, Ms. McDuffie? Ms. Kreischer?
Yes, Your Honor.
Thank you. I find that there's a factual basis for the pleas when willingly and knowingly made. I'm going to accept your plea, ma'am.
Thank you.
All right. So at this point, you think that a bail would be available to her by?
I'm hoping in a week or so, Your Honor. Again, we don't know exactly when that would happen. That's the latest and most accurate information that I received from Ms. Stewart.
All right.
And that was on Thursday that I received that information.
And what is your request at this time?
As we were here the last time, the court said it would consider releasing her home to take care of some things and then she would report to treatment on her own. I would ask the court to allow her to go home for the following reasons. First of all, my client does need to make sure she takes her medication, that she is not getting at the jail. Further, it's been reported to me by my client that monies have been taken out of her account. She needs to make sure that that situation is handled by going to the bank, probably closing that account, directing funds from her Social Security to be deposited in a new account. And I don't know when her Social Security gets deposited. It's generally the first of the month, but I'm not sure. And also to ensure that her apartment is still in good working order. She's been gone. It's our understanding possibly that Mr. Lee has been able to access that apartment. And finally, she needs to locate her car. It's our understanding and belief that Mr. Lee had access to her car. I understand, and maybe Ms. McDuffie can confirm that Mr. Lee is currently, no, I think I confirmed through Vilink that Mr. Lee is bonded out on the matters that he has before the court, and that he could be in possession of her car. So she has some things, personal things I think are serious that needs to be taken care of. And the alternative, if the court she'd be willing to put on a GPS tether and comply with any testing requirements that the court has. I understand that is a hollow request given the fact that she had a probation violation for failure to test and also positive tests. But I believe that her time in the Washtenaw County Jail has given her some insight into, one, her situation with Mr. Lee and how harmful it was to her, and secondly, into her cocaine issue. So again, I'm asking for the court to release her. And the alternative, if the court is not willing to wait that long on her release, then at least release her for a short time period, maybe 3 days, so she can get these items taken care of. Then she can self-report back to the Washtenaw County Jail until a bed's available, Your Honor. Thank you.
Ms. McDuffie?
Your Honor, I was going to ask her approach, but I'll just put all this on the record. The last time that we were here, Mr. Lee was in custody on a DV third case with a different victim. I was concerned at that time. I've made no secret of the fact that it is Ms. Beldaiga's safety that I'm primarily concerned about with this relationship. And I was concerned that he was going to potentially get released, and I did not want her to be in further danger, obviously, given that. Mr. Lee is back in custody again today because he was given a PR bond at that last hearing, violated 3 times within the past week since we've last been here, and he is now in custody today. Again, I would hope that we originally asked for $50K on his case. It didn't get it. I would hope that now, but I still can never guarantee what's going to happen. So not knowing what's going to happen with him for another hour or so until he gets arraigned on those violations. My concern was just that, for example, home confinement. I didn't want Ms. Beldaiga trapped in her house where she cannot get away if she faces danger. I don't have any problem. Obviously, I want her to go to treatment, but we're unfortunately kind of the same difficult situation we were in last week, not knowing where he's going to end up. So I just wanted the court, Ms. Prasher and Ms. Beldaiga, to all have that background in terms of what's going on there. I will defer to the court in terms of what the best solution is here, but the danger may still be present for her.
All right, Ms. Beldaiga is going to be released on a home confinement tether.
Thank you. Thank you.
And she is to go directly to treatment upon when the bed is available.
Yes, right.
No contact with Don Lee. You're to test. I'm going to make it 4 times per month. So,
okay,
ma'am, if you test positive, I'm going to just put you right back in jail. If you have
I understand, Your Honor. I will not test positive.
If you have contact with Don Lee, I'm going to put you right back in jail. And that you stay home, except for going to treatment and to the banks.
Can I go to the grocery store? Well, first I have to buy my car.
And the grocery store. If you,
Thank you.
car is not where it needs to be, I suggest you report it stolen, ma'am. That's what you should probably do. You're not gonna be running around looking for a car.
Oh,
Okay?
I know. I know that, Your Honor. I didn't mean to imply that.
All right. And then, I guess I need to schedule you for a sentencing. I'll schedule you for a sentencing on April 8th at 10 a.m.
Okay.
You need to contact the probation department in order to have a pre-sentence investigation report done before then.
Okay. I talked to my lawyer and I sent a kite to Sarah. I want to get out of Michigan. I want to get away from him. I know we don't know my sentence yet, but could I do my probation in Oklahoma?
You can talk to probation department about that. Right now, we're
Okay.
with treatment. Okay?
Thank you, Your Honor.
Thank you. All right. Have a good day, everybody. Address Bob.
As the court knows, Mr. Buck has not been testing and he does admit to that. And he has been having trouble with transportation. He does want the court to know that all of his tests have been negative when he did test. He is asking for release. He will do home confinement if necessary, but he asked for release with tether. If the
Thank
court
you.
would like.
Response. Response, Ms. Duffy.
Your Honor, unfortunately, it's no reassurance that the tests that he did take were negative when they're so few and far between. I think that's kind of the point, is that we don't know what's really going on because he shows up so not very often. So I'll leave that to the court. I don't really know what else to say about Mr. Buck and testing.
Well, I think the prosecutor said enough, which is that in effect, Mr. Buck shows up when he wants to, and there's always an excuse about his vehicle. It's interesting that he was at home when he was arraigned, telling me that his vehicle didn't work, but then when he was picked up, he was 6 hours away. Where his vehicle had, in his opinion, broken down again. So he may be having transportation problems, but he can use it when he wants to. I've heard enough, Mr. Buck.
I'd say it may have been worded improperly by the last attorney.
Mr. Buck is saying that I did not word things correct.
No, I think it was during the arraignment, actually, that the representative during the arraignment, she did not relay the information properly as I had explained it to her. That was when I was up north. She relayed that the truck was currently broken up north, and it was not. It was broken before, and then I had left to go up north to help my sister out and see my grandfather who has cancer and is not doing too hot, but subside any of that.
The bond motion for release on home confinement is denied. I will give him it's a standalone. I will give him, he's at the pretrial stage, so he's entitled to a bond. Bond in this case will be $25,000. Cash or surety. If paid, he can be released on home confinement.
So is that 10% or no 10%?
No 10%, sir. It's cash or surety.